We're now at part 4 of this fascinating sledding accident case where I found an old transcript hiding in some papers, and now I want to share with you the rest of what I said in closing remarks. You want to learn what happened here? Come join me as I share with you this great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial lawyer practicing law in the state of New York. Again, you should know that before I started out my career representing injured victims, for the first 4 years of my legal career, I represented people who were sued in accident cases. And as I was cleaning out some papers in my home, I came across a transcript of a case that I tried back in May of 1990 in Mineola, where I represented a winter resort up in the Poconos. And here's what the case is about. A gentleman and his wife go up to the Poconos. They're going with a couple that they know, and now it had just snowed, and they wanted to go sledding down this hill. And ultimately, this guy takes one of these little flying saucers, gets on it, and spins around. As he's going down, builds up speed, hits something at the bottom, flies off, and breaks his tailbone. And now, this is the closing remarks. We're now up to part 4, so listen in. It's really fascinating. Plaintiff traveled. It's his testimony that he traveled 70 feet from the point where he got on that sled to the point where this incident occurred. 70 feet in 4 seconds. 4 seconds! A little bit of math and the judge is going to give you a calculation. He'll give you a formula to determine how fast he was going. But if you merely divide the time it takes to travel 70 feet, you can determine how many feet you're going per second. That would be 17.5 feet per second. Now, 17.5 feet per second is kind of a hard concept to really understand. Most of us are familiar with traveling in cars, driving cars. We know about miles per hour. So there's a simple little formula that the judge is going to give you that you can even calculate yourself. And by plugging this number into the formula to find out how many feet per second equals miles per hour, it comes out to about 11.5 to 12 miles per hour. Now, driving a car, that may not seem much because in cars we're used to going considerably faster. But getting on this sled all alone in the nice winter air on a little dinky sled, 180 pounds of man, you're going down a hill with no brakes, no way to steer, going 11 or 12 miles per hour is fast. That's not slow at all. That may be like riding a bicycle down a hill, and this is fast. For a sled like this, that's uncontrollable, that spins, you're really moving now. And the plaintiff said he was moving slow. Slow. Well, let me tell you something. If you're moving slow, if you're going slow on this thing, you simply don't have any fun. You get down to the bottom of the hill if you're moving slow, and it's not a refreshing feeling. And the only way to have a great time on this thing is if you're going fast. And ladies and gentlemen, he was going fast. Now what happened here? So now what I'm doing is I'm setting the jury up to get them to understand in their minds exactly what was occurring. Now, he's coming down. We're still up on the hill. 3/4 of the way down, something happens. Nobody knows what happens. Plaintiff doesn't know. His wife doesn't know. The neighbor doesn't know. These are all people who are watching him go down this hill continuously. They don't know what happened. Now, the owner's son, who saw from the kitchen the guy go down the hill, he didn't know what happened at the time. A day later, he comes out to examine the area to see what might have caused it, and all he could find were railroad ties. But he doesn't know for sure that that's what it was. Maybe there was a rock there that someone moved overnight. Maybe there was something else. Ladies and gentlemen, we just don't know. I wish we did. I wish someone could say, yes, this is what it was, this is what caused this incident. Because if we knew then, we wouldn't be here. We would not be here. But the reality is, we don't know. Now, the plaintiff says that because there were no signs up, now here's part of the argument that I'm trying to address and get the jury to focus on to realize this is a ridiculous argument. Now remember, in New York, in an accident case, the defense makes closing remarks first. And when I'm done, the plaintiff, the injured victim's attorney, then goes ahead and gives his closing remarks. So he's the one who actually has the last word. So now I'm raising an argument that I believe the plaintiff is going to raise, and now I have to address it and get the jury to focus on how ridiculous this argument really is. Plaintiff says that because there were no signs up, I presume he'll say that, because there were no signs up on that hill that this incident occurred. And ladies and gentlemen, there were no signs up. Now here you have the beautiful country inn run by a family. They have 400 acres. 400 acres of terrain, of land with different topography. You have hills, you have flat places, you have forests, you have all kinds of different areas. What are you going to do? Are you going to put up signs for every single type of event, for every possibility that can occur, for every single season that can happen? I'm setting this up to make fun of the plaintiff's argument, to show them how ridiculous this argument is and really how preposterous it is. So what are you going to have? Signs that say, beware, roadway ahead? Or one for the summer, beware, don't walk in grass. Could get stung by a bee. How about this one? Beware, rocks below. Or beware, tree stump over there. Beware, don't ice skate on the pond, ice could break. So I'm explaining to the jury and pointing out this argument is absolute nonsense, and putting in the jury's minds and the recognition that what they are claiming here made absolutely no common sense. And that's one of the things that I get them to focus on during the course of my closing remarks. So come join me in the next video as I continue on as we finish up these closing remarks and I show you exactly what I did and why. I realize you're watching this because you likely have questions or concerns about your own particular matter. Well, if your matter happened here in New York and you do have legal questions, what I encourage you to do is pick up the phone and call me. I can answer your legal questions. This is something I do every single day and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's quick video. I'm Gerry Oginski. Have a wonderful day.